Start. The SEC, a cooperative society, engaged in the business of providing credit facilities to its members and marketing their agricultural produce, invested the surplus funds in short-term deposits with the banks and in the government securities, and earned interest thereon, full stop. The SEC showed the said interest income under the head income from business, but the assessing offer assessed it as income from other sources under section 56 and held that the SEC would not be entitled to deduction under section 1/80 80p2a of the Income Tax Act, full stop. In the instant appeal filed by the SSC, the question for consideration before the court was whether the interest income earned by the SSC Society on surplus funds invested in short-term deposits would qualify for deduction as business income under section 80p2a of the Income Tax Act, 1961. Dismissing the appeals, the court held an income which is attributable to any of the activities under bracket 2/160 specified in section 80p under bracket 2 of the Income Tax Act, 1961 would be eligible for deduction, full stop. In the instant case, the interest held not eligible for deduction under section 80p under bracket 2 under bracket a is not the interest received from the business of the society, namely, providing credit facilities to its members or marketing their agricultural produce, full stop. What is sought to be taxed under section 56 of the act is the interest income arising on the surplus, which surplus was not required for business purposes, and was invested in specified securities as investment, full stop. SSC markets the product of its members whose sale proceeds at times were retained by it, full stop. Since the fund created by such retention was not required immediately for business purposes, it was invested in specified securities, full stop. Such interest income would come in the category of income from other sources and, therefore, would be taxable under section 56 of the act, as rightly held by the assessing officer, full stop. The word income has been defined under section 2 under bracket 24 under bracket I of the Act to include profits and gains, full stop. This subsection is an inclusive provision, full stop. The Parliament was included specifically business profits into the definition of the word income, full stop. Therefore, the court is required to give a precise meaning of the words profits and gains of business mentioned in section 80p under bracket 2 of the act, full stop. In the instant case, SSC society regularly invest funds not required for business purposes, full stop. Interest on such investments, cannot fall within the meaning of the expression profits and gains of business, full stop. On this backdrop, when the evidence of PW11, the medical officer is seen that at 9 am itself, the doctor examined PW2 on the requisition of SHO, rural, who was accompanied by police constable who was PW14, full stop. There is no question of PW1 registering the FIR. PW14 also admitted that even by the time they reached the hospital, MLA was stated to have come to the hospital and the legal advisors were also found in the hospital, full stop. A compromise relating to shares in the suit property was entered into between the plaintiff appellants and the predecessors in interest of the defendant respondents full stop. The plaintiffs filed a suit for declaration that they were in possession as owner of share and in joint possession of half of the share of the land along with the respondents, and the entries in the revenue record of rights should be corrected full stop. The trial court dismissed the suit, accepting the defendant's plea that the suit, having been filed under 18 years of the compromise full stop, was barred by limitation in view of the Article 58 of the Schedule to the Limitation Act, 1963, whereunder the suit have been filed within 3 years of the compromise full stop. The plaintiffs have remained unsuccessful in the first appeal as also in the second appeal, filed the appeal full stop. In the instant case, the right to sue occurred when a clear and unequivocal threat to infringe that right by the defendants was given, as they refused to admit the claim of the appellants, only 7 days before filing of the suit full stop. Therefore, as noted in paragraph 16 of the plaint, the suit was filed within 3 years from the date of infringement and, as such, the suit cannot be held to the barred by limitation, full stop. The courts below, including the High Court, had proceeded entirely on a wrong footing that the cause of action arose on the date of entering into the compromise and, therefore, the suit was barred by limitation, full stop, whether or not the compromise decree was acted upon and whether delivery of possession had taken place has to be decided by the trial court before it could come to a proper conclusion that the suit was barred by limitation, full stop. The question of filling the suit before the right accrued to the plaintiffs by compromise could not arise, full stop.